All right, let's get into it. Today, we're stepping into the world of high stakes financial crime. We're going to be looking at something called culpable insolvency. Now, that sounds like some dry legal term, but trust me, it's really about a very human, very calculated kind of betrayal.
I want you to imagine something for a second. Someone owes you a lot of money, a lot. And when it's time to pay up, they're just gone. Their business is locked up, their phone's disconnected, and all that property they used to have, it's somehow vanished, transferred to a cousin, sold for cash, hidden somewhere you'll never find. They throw their hands up and say, "Sorry, I'm broke." But you get this feeling deep in your gut that you've been totally and completely played. Well, that feeling, that deliberate disappearing act, that's not just bad luck. It's a crime, and today we're going to pull it apart piece by piece.
So, here's our game plan. First, we're going to really nail down what this vanishing debtor problem is all about. Then, we'll put on our forensic hats and perform an anatomy of the crime itself. After that, we get to play psychologist and go inside the offender's mind. Then, things get interesting because we'll look at a tale of two very different kinds of debtors. We'll explore if there's any way to defend against this charge, and finally, we'll see how the law lays down its final verdict.
Okay, first things first, we have to draw a really, really clear line in the sand. A business failing is not a crime. Let's be real, it happens all the time. Markets change, a great idea doesn't pan out, luck just runs out. That's life. That's business. But what we're talking about today is a whole different animal. It's the critical difference between simple misfortune and outright malice. Think of it like this. It's this sinking ship metaphor. On one hand, you have what's called fortuitous insolvency. This is the tragic accident. A massive, unexpected storm rolls in, a recession, a pandemic, whatever, and it just sinks the business. It's terrible, but it's nobody's fault. But then there's culpable insolvency. This is no accident. This is sabotage. This is the captain of the ship seeing the storm coming, and instead of trying to save everyone, they secretly go below deck, drill holes in the hull, load up the only lifeboat with all the treasure, and slip away in the middle of the night, leaving you and all the other creditors to go down with the ship. One is a tragedy. The other is a calculated, cold-blooded crime. And the law has a name for this. Under Article 314, it's called fraudulent insolvency. Now, the key phrase here is absconds with their property. Absconds. What a great word. It doesn't just mean leaves. It means to disappear, to flee, often with something you shouldn't have, to avoid being caught. It's a magic trick, making assets vanish into thin air. And it has to be to the detriment of their creditors, meaning your loss is a direct result of their disappearing act. This is the legal hook they use to go after that saboteur captain. All right, now that we know what we're looking for, let's put this crime on the operating table and really dissect it. Just like any other offense, from petty theft to murder, fraudulent insolvency is made up of a few key ingredients that a prosecutor absolutely has to prove. So let's break it down. Think of this as the who, what, and why of our investigation. First, we need the act. What physical thing actually happened? Then we need the offender. Who's the person responsible? And finally, we look at the harm. What was the actual damage that was done? Get these three things, and you've got the whole picture of the crime. So, step one is what lawyers call the actus reus. Don't let the Latin scare you. It literally just means the guilty act. This is the physical part, the part you can see and touch. See, you can't be arrested for just thinking about hiding your money from people you owe. You have to actually do it. This is the smoking gun. It's the signed document, the shady bank transfer, the faked sales receipt. It's the concrete, undeniable proof that someone took action to make their property disappear. So what does this absconding actually look like in the real world? Well, it can be pretty clever. It could be selling your $1 million house to your brother for $1. Or maybe you sell your fancy car for a briefcase full of cash that you then conveniently lose. A classic move is emptying out all the business bank accounts right before you declare bankruptcy. Or, for the big players, moving assets to some offshore account that's nearly impossible to trace. You can even fake a robbery of your own warehouse to write off all your valuable inventory. Each one of these is a different way to play the same shell game. Next up, the offender. Who's our culprit? Well, legally speaking, it's the debtor, the person or the company that actually owes the money. In our sinking ship story, it's the captain. They're the one holding the map, the one at the wheel, and the only one who truly benefits from the sabotage. And finally, the third piece, the harm. Now, the obvious harm is you, the creditor, being out of pocket. You're left holding an empty bag. But the damage actually goes way deeper than that. This kind of crime eats away at the very foundation of our economy, trust.
Think about it. Commerce only works if we trust that contracts will be honored and debts will be paid. When people start sabotaging their own ships, nobody wants to set sail. So the harm isn't just to one person, it's a crack in the entire system. Okay, so we've got the physical evidence, we have the paper trail, we know what they did. But that is only half the battle. Believe it or not, to get a conviction, you have to prove not just what they did, but why they did it. We have to move beyond the crime scene and get inside the offender's head. And this brings us to our second fancy Latin term, mens rea. It means the guilty mind. This is the secret ingredient. It's the intent. The prosecutor has to show that the debtor acted with the specific intent to defraud. Here's a simple way to think about it. It's the difference between accidentally tripping and falling into someone versus deliberately balling up your fist and punching them. The result might be the same, someone gets hurt, but the intent is what turns an accident into an assault. Same thing here. Intent is what turns a business failure into a serious financial crime. Now, of course, criminals don't usually write down their evil plans. But this quote right here, this is the internal monologue. This is the thought process. It's that conscious, calculated decision that says, I know they have a legal right to this asset, and I am going to create a scheme to make sure they can't get it. It's not panic. It's a plan. It's deception, plain and simple. So far, we've been talking about this crime like it's the same for everybody. But here's where things take a fascinating turn. The law actually makes a huge distinction. It basically splits offenders into two completely different categories, and it treats one of them way more harshly. It's a tale of two debtors. So on one side, you have the non-merchant. This is just a regular person, a private individual. Their financial dealings are mostly personal, and if they commit this crime, the impact, while serious for those involved, is usually limited to a smaller circle. But then you have the merchant. The law sees them differently. They are a captain of commerce. Their business is built on a web of trust with suppliers, employees, customers, and lenders. When they decide to sink the ship, the ripple effect can be massive, potentially taking down other businesses with them. Because their betrayal can do so much more damage, the law holds them to a much, much higher standard. And that higher standard isn't just talk. Take a look at the difference in the potential prison time. It's right there in black and white. A merchant is looking at a sentence of up to 12 years, which is significantly more than a non-merchant. That's the law basically saying that if you're a captain of commerce, your duty to your crew and the other ships around you is greater. And so is the punishment for betraying that trust. Okay, we've spent a lot of time looking at this from the prosecutor's point of view. But what if you're the one being accused? Let's flip the script. Is there any defense? I mean, the law is supposed to punish criminals, not people who just had a string of terrible luck. And the answer is yes, absolutely, there are defenses. The entire defense strategy boils down to one thing: attacking the idea of the guilty mind. The defense attorney's job is to prove there was no intent to defraud. They'll argue that their client was making bad, maybe even panic decisions, but not malicious ones. They have to paint a picture not of a saboteur with a drill, but of a desperate captain trying to bail out a ship that was already sinking in a storm. And that, right there, is the million-dollar question, isn't it? It's easy to say, I didn't mean to, but words are cheap. How on earth do you prove your own state of mind to a judge and jury who are looking at a mountain of suspicious paperwork? Well, the answer isn't in what you say. It's in what you did. The court basically puts your actions on a scale. On one side, you have mitigating factors, things that show good faith. Did you try to negotiate a payment plan? Did you come clean and return a hidden asset? These things make you look less like a criminal. On the other side, you have aggravating factors, things that show bad faith. As we've seen, just being a merchant is one. The more creditors you harmed, the bigger the hole you left them in, all of these things weigh against you. And the judge uses this scale to figure out if you're the victim of a storm or the one who caused it. So, we've been through the whole process. We've dissected the crime, we've gotten inside the offender's head, we've even looked at the defense. So now it's time to get to the bottom line. After all the evidence is presented and all the arguments are made, what is the actual price for this kind of fraud? And this table is where the legal theory becomes very, very real. For a merchant, the penalty is called prison mayor, and it carries a sentence of 6 to 12 years. For a non-merchant, it's a bit less, but still a hefty 4 to 10 years. These are not small numbers. This isn't a fine or a slap on the wrist. This is years of a person's life, which shows you just how seriously the law takes the betrayal of financial trust. And all of this leaves us with one final big question to think about. We live in an economy of booms and busts. Risk is part of the game. Businesses are supposed to take risks, and sometimes they fail. So the massive challenge for our legal system is this: how do you draw that incredibly fine line between a failed risk and a calculated fraud? How do you separate the unfortunate captain whose ship was genuinely sunk by a storm from the criminal who deliberately scuttled their own vessel for profit? Finding that line is the entire purpose of this law, and it's a puzzle worth thinking about long after this is over.